Is a bail matter? Take it.
So, Lordship, one more initial matter. Extension of the engineering order was expired. Will be expired on September 2023. Because we let the matter be kindly listed tomorrow.
Criminal revision.
Yes.
See, move a CRAN application.
Lordship, I'm now within time. So
No, but for the extension, move an application, it will get listed. You move an application, it will get listed. You mention it tomorrow, move an application. You want an interim extension.
Actually, last Sundays, if I move it within the period of the interim order, then no such application is required. So I did not file any application for this. And if the matter is listed, then I have no problem.
So what is the general practice? You don't need to move an application for extension. For extension of interim bail, do you need to move an application or not?
Lordship, first of all, I'm just asking to list it matter for hearing.
You're asking it to be listed for hearing only for the purposes of getting an extension, right?
Lordship, matter is that if the interim bail has been granted, only the listing is required, and depending upon that, the honorable bench will decide whether the bail to be extended or not, Lordship.
So you don't need to move an application.
No, Lordship.
All right.
Only mentioning is required, Lordship.
List.
My lord, may I permit to mention one criminal revision application, my lord?
Which application?
Criminal revision, my lord.
Yes, what is there?
My lord, this is a matter under application 482 matter to set aside the input order, that is judgment that is passed by the additional session judge in Siliguri for conviction under section 14A, my lord, and subsequent other section also.
Take it.
Answering item number 1.
That's the one.
My lord.
Yes.
My lord, it's my. I want to get a first hearing date till 7th August. I am not getting a first hearing for first hearing, my lord. Please kindly tomorrow. Please kindly, my lord, tomorrow for first hearing. 207 of 2023, sir.
What is there in the matter?
Matter CRR 207 of 2023 for quashing matter, my lord. Kindly, my lord. Tomorrow or Friday, my lord.
Final caution, not right now. The board is already heavy. Not tomorrow.
My lord, any day for fast hearing, my lord. Kindly, my lord. For fast hearing.
Call the.
Hearing item number 1.
इसमें आप ये कर देना. In the inadvertently, it is noted that inadvertently CAN 2 of 2022 has been mentioned in the order. The same needs to be deleted. Let the same be done. With the above direction, just remove the CAN. But the same needs to be deleted.
Item number 2.
Pass over. Three to 10.
3 to 10, Lordship.
Item number 3.
Similar orders are the last ones.
Lordship,
Lordship.
I am for response number 4, that is State of West Bengal. Lordship, kindly sees the Gorkhaland Territorial Administration Act.
No, what's the point of seeing the act? There are orders passed by the.
Lordship, so
Coordinate bench of this
nothing
court.
against, we don't have any, or the GT in GTA subject to the provisions of any
Respond
other.
number- Who appears for respond number 2?
Supriya Singh. Lordship, I have served the copy. This is the
Letter ka caller.
Lordship.
We'll dispose it off in the same term.
Lordship.
Obliged, Lordship.
Former respondent of the state.
Yeah, so don't show the Gorkha Land Act. There's no point. The coordinate bench of this court has
Yes,
already
so
passed similar order.
As per the act, the state government has nothing to do, it's the GTA.
If your Lordship requires this statute, I can hand it over to you.
No, what's the need? Already you have, more
Obliged.
petitioners have filed petitions like
Lordship,
this. Orders have been
Lordship.
passed. You just call Miss Singh, we'll pass an order.
Lordship. Hey, should be yes.
She's here. Give
She
the.
has come, Lordship.
Miss Singh, earlier also, similar set of petitions have been filed. Orders have been passed. We'll pass the same.
Aaj ki kisi
No,
government
that's
question.
the same order I'm gonna pass. What has been passed in the other matters. Take down. The petitioner in the present writ petition is working as teacher in charge of a government aided school situated at the hill region of West Bengal, which falls under the control of GTA. Full stop. The district inspector of schools bracket में S.E capital comma GTA comma Darjeeling by an office memo number 1015/SE S capital E capital dated 26/7/2018 recommended that all TICs capital TICs working in the GTA region having sufficient educational qualification to be appointed as headmaster / headmistress of their respective schools. It is the case of the petitioner that despite various representation, the petitioner was not appointed as headmaster / headmistress. Next, full stop. Learned counsel for the petitioner pointed out that this court in WPA 917 of 2019 titled as Mahendra Chetri versus State of West Bengal has considered the case of similarly situated people and had directed the respondents to consider their representation, keeping in mind the recommendation of the district inspector of schools bracket S.E bracket close comma GTA comma Darjeeling full stop. Learned counsel for the petitioner submits that he will be satisfied at this stage comma, if a similar order is passed in this matter too. Full stop. Learned counsel for the respondents have no objection in adopting the same course of action. Full stop. Hence the writ petition.
Can you please read the last line of the petition? Because I heard that you have mentioned that we have no objection.
The same thing which I am doing in the other matters. Learned counsel for the respondent has no objection in adopting the same course of action. With the same course of action, you have to decide the representation. Hence, the present writ petition is disposed of with a direction to the respondents to consider the representation of the petitioner, keeping in mind the recommendation of the district inspector of schools, comma GTA, comma Darjeeling, after affording a personal hearing to the petitioner. Full stop. The respondent The respondent shall conclude the said process within a period of how much time? 4 weeks from today, full stop. The respondents are directed to communicate the outcome of the said hearing by way of a speaking order, full stop. Needless to state, if the petitioner is aggrieved by the decision taken by the respondent, comma, he shall be at liberty to challenge the same in accordance with law.
Obliged, Lordship.
Full stop. It is clarified that since no affidavit in opposition has been called for, comma, the allegations made in the writ petitions are deemed to have not been admitted by the respondents.
Lordship.
Full stop. The present writ petition is disposed of in the above direction.
But I am for respondent 3 in 5, 7 and 9.
Five questions of this connection.
Fourth.
So just give your appearances in different matters. Just give your appearances. In all the matters from 3 to 10 in the same order. Different petitioners. You're missing your appear in all the matters. The rest of you just give your appearances.
3 to 10, same.
Yes.
Grateful, Lordship.
Item number 2, Lordship. It is prepared for the respondent, Lordship. The
We have passed it over. Just passed it.
3 to 10 over there.
Item number 11.
Lordship, I am on behalf of the petitioner, Lordship. This is the affidavit of service, Lordship.
Who appears for the Siliguri Municipal Corporation?
Devorshidhar appears usually, Lordship. Devorshidhar, learned advocate Devorshidhar appears for Siliguri Municipal Corporation. I have seen in the bar. I have seen him in the bar.
The petitioner has filed the present writ petition alleging that the petitioner has filed the present writ petition alleging that respondent number 5 is carrying out unauthorized construction by erecting a multi-storied building in contravention of the prevalent laws. Full stop. Prevalent laws. Full stop. It is the case of the petitioner that based on his complaint, comma, the respondent number 4 issued an office note whereby they admit that the respondent number 5 is carrying out unauthorized construction. You appear?
I am at the party number 5.
You are carrying out unauthorized construction.
Lordship, may I submit?
Wait. Despite the said office note, respondent number 5 is continuing with the unauthorized construction and hence left with no other option. The petitioner has filed the present writ petition. Full stop. Issue notice to the respondents. Mr. So and so accept notice, Mr. What's your name? Anirban Banerjee. Accept notice on behalf of the private respondent number 5. He states,
Lordship, if there is any unauthorized construction, Lordship, this is this should be a public interest litigation, not a.
No, Lordship.
not at all,
Not at all, Lordship.
not at all.
How
not
can
a-
how he is agreed?
He states that if he is carrying out any unauthorized construction,
I am not admitting to his allegations,
Then-
Lordship.
the petitioner shall file a public interest litigation and the present writ petition is not maintainable. Full stop. It is made clear that the petitioner is a neighbor,
Lordship.
and is aggrieved by the unauthorized construction being carried out by the respondent number 5 and if the same is being done in contravention of the building bylaws or any other statute or any other prevalent laws, then the petitioner has all the right to challenge the same before this court. Who's for respondent number 2?
Corporation.
Yes, Mr. You appear for the corporation, Mr. Debashri Dhar appears on behalf of respondent number 2 corporation and seeks time to file affidavit in opposition and assures the court that if any unauthorized construction is being carried out, the same shall be dealt in accordance with law.
Yes. Lordship, till he files the affidavit in opposition, let there be a stay, Lordship.
No.
Because already the private respondent has failed to provide any.
The corporation shall carry out an inspection within 2 days.
Obliged, Lordship.
File their report within a period of 1 week. Full stop. Let this matter appear before the next available circuit bench.
Obliged, Lordship.
Lordship, let the point of maintainability be kept.
Point of?
Point of maintainability. be
I have
kept.
noted it down. I have rejected it.
ঠিক আছে, কোনো অসুবিধা নেই।
My lord, item number 12, I was directed to serve an affidavit of service upon
Yes.
the respondent number 6. But my lord, today I have seen the status report. It
Yes.
is sent from here. It's arrived at Kolkata, but it's not yet delivered.
Learned counsel for the petitioner states that the respondent number 6 has not been served. And he shall
I
file an
understand, but not-
he shall file an affidavit of service before the next date, within a period of 1 week.
My lord, if it could be kept on Monday. It is difficult for my lord to
Let this matter be listed before the next circuit bench.
grateful.
Item number 13.
The service has been effected upon the respondent. Lordship, it is that matter, Lordship, where the 2.5 lakhs Lordship is due since 2018. Lordship, all persuasion has already been has done. Yes, Lordship.
How is this maintainable? You're asking for recovery of 2,49,000.
Yes,
In a writ petition.
yes. Tender was issued.
So what?
So tender is a government tender.
So what?
It's a government tender.
So what?
The work order is there. Since the work
What is
order,
there? You can't be coming to the court asking for recovery of money which you have not been paid for carrying out the work.
yes, the government work. Lordship, it's a private treaty. Lordship, I am saying, Lordship, Article 299. Article 299 appreciate this thing.
You show me any authority where the court acts as a recovery agent in a commercial contract.
Not commercial, Lordship, it is a government. Article 299 is a government contract.
Even if it's a government contract, you cannot come to the court seeking recovery of money, please. You withdraw this, Mr. Shah. Learned counsel for the petitioner seeks to withdraw the
Lordship,
present.
not Lordship, not next circuit, Lordship. It may be next.
No, then I'll decide it. You want me to decide it, then I'll dismiss it.
Lordship, I have to go through the authority and all, Lordship. That's why I'm saying, Lordship is seeking authority,
Who's
Lordship.
appearing for the other side?
Actually, I don't know, Lordship. They have served. Every service is there.
Who's there? Who's the counsel? You'll know that.
Lordship, I don't know. This is the first time.
Who's the respondent? Government.
Government,
So see who's there for the government. We'll pass it over. You call the person.
Lordship.
Call the person. We'll pass it over.
Item number 14.
Pass over.
Item number 15.
I am for appeal, my lord. Well, this matter was last time appeared But there is.
The certified copy of the impugned judgment has not been received with the necessary insertions.
Yes, my lord.
Just do that.
No, my lord,
It's not there. Learned counsel for the petitioner.
my lord, suppose it was returned, my lord. Because my lord, in last occasion, there
So
is.
you have to make those changes and then you file it. You can't just file it like this.
No, my lord.
Just
my lord,
take down
I
the
filed-
certified copy of
No,
the
my lord,
impugned.
my lord, I filed the certified copy. Actually, what is happened, my lord?
So the insertions have to be there.
No, my lord, there is a, because my lord, they are not endorsed the stamp behind the certified copy, my lord. That's why it was sent back to the copy department of Jalpaiguri. And
Yes.
it was returned back, my lord. Suppose I have information, according to my information, it was returned back with endorsement, my lord. Because I was obtained the copy on 5th of December.
So you have to check up with them.
My lord, I check up, can you pass it over, my lord?
Pass it on.
Pass it over. It will record it.
Yes, my lord. I am from the insurance company, my lord. This is the first time, my lord, we allow the insurance company to serve the notice of authority. And also please to call the LCF on the lower court, my lord.
Have you deposited the statutory
Yes,
amount?
yes, yes.
It says you have not.
Yes. Yes.
Where is it
Yes,
show?
It is there, my lord.
Where is the receipt?
Yes, my lord.
There's a wrong note.
Yes, my lord.
Ranjan. It's a wrong note. See the note. No, it's a registry's fault, not his fault. You have given this to the registry.
Yes.
See the note. See the note.
It is said that they verify and report at all.
No, it says that you have not deposited the statutory amount.
But there is a receipt, my lord. We draft copy, not check.
देखो इसमें क्या है?
I have a Xerox copy.
1/8. All right, we'll have it tomorrow then. We'll keep that on record. Keep it for tomorrow. Just give us a Xerox copy of that. You list it tomorrow and correct the note. उसके बाद आया हाँ बाद आया देख लेना.
It's actually the principal bench.
At the request of the learned counsel for the petitioner, let this matter be listed tomorrow. कल का रख दो.
Item number 78.
My lordship, I am for the insurance company, my lordship. This is the first time, my lordship. I have to insert the notice and.
The appellant insurance company is challenging the judgment and award dated 12/4/2023, passed by the additional additional session judge MACT in MAC case number 42 of 2020, full stop. While the impugned award, the learned trial court was pleased to pass an award of rupees 72,53,416 in favor of respondent number 1 herein, full stop. Upon the appellant depositing 50% of the decretal amount, we can deposit with the registry here,
Yes, my lord.
with the registry of this court within a period of
6 weeks.
6 weeks, there shall be a stay of the operation of the impugned judgment, full stop. Upon depositing the said amount, the same shall be released to the respondent subject to the respondent number 1 providing adequate security to the satisfaction of ये रंजन यार रजिस्ट्रार जनरल देखते हैं ये matters. How do you release the money with the security?
There's no security actually. Just release.
Just release. And tomorrow if the matter
Then it is problem.
then
Then it will be deposited in the until the.
if the poor guy can't return the money, then what will you do?
That is the problem. I don't.
See, generally, what we do is we release the amount
Yes, madam.
subject to security to the satisfaction of the registrar general of the court.
This order.
It happens
First
here?
time, but this-
Okay. Security to the satisfaction of the registrar general of this court. Full stop. Registrar general of this court to the satisfaction. कहाँ तक लिखा आपने? Subject to the respondent number 1 providing adequate security to the satisfaction of the registrar general of this court. Ranjan, to the registrar होगा ना? Registrar circuit bench of this court. Learned counsel for the appellant is directed to file the affidavit of service. List this matter before the next available circuit bench. ठीक है ना? Item 18 is also same.
Insurance company, my lordship. We paid for an appeal. That is the first time, my lordship. And there can also. And lower.
You have deposited the statutory amount.
Yes.
Again, the notice here that you have not. When did you deposit it?
Here is the report, ma'am. For moving that, they've already said.
सेम ऑर्डर कर लेना आप इसमें भी ठीक है ना इसमें सिर्फ चेंज हो जाएगा आपका मैक नंबर 80 of 2020 and date of judgment will change to 20th/4/2023. Even the earlier matter is the same. जिसमें हमने कल के लिए रखा है ना उसको भी सेम ऑर्डर पास कर उसमें मैक नंबर और डेट ऑफ जजमेंट चेंज है दैट्स Yes, Ms. Acharya,
Item number 19.
you're doing it today.
Yes, my lord. She is being led by me, my lord. I have prepared her for this hearing, my lord.
That's
I
very
want her to do this matter, my lord.
nice of you, Mr. Day. I was compelling her to argue yesterday.
Yes, yes, my lord, my lord. It's the pleasure for the junior to argue
That-
before your lordship.
To have the opportunity. And I'm glad we have seniors like you, Mr. Day. The opportunity.
I'm watching. She will do the matter, my lord. She will do the matter.
Yes, yes, Mr. Day. We encourage this, Mr. Day. That's very nice of you. Yes.
Lordship, kindly come to the allegation is that the petitioners, they
Yes.
had exploited the complainant, that is the opposite party number 2, that they using her caste as she is from the scheduled tribe community, your lordship. So
Yes.
in section 389 has been 389 and 34 of the IPC has been allegedly put against the petitioners, your lordship, whereas the fact of the case is that, your lordship, the petitioner number 2 used to own the plot of land where the opposite party number 2 has a shop, your lordship. So subsequently, the petitioner number 2 sold it to petitioner number 1, who used to work as a maid servant of at his home, your lordship. So, and she belongs to the tribal community, your lordship.
Yes.
So stating that, I have annexed the deed, your lordship, that is my annexure A in page 11, that the,
Let us see that.
yes, in page 12, your lordship, it is in Bengali, your lordship, so there is no translated copy of the same.
No, no,
your
I don't need it.
lordship.
It's a sale deed, right? Page 11.
Yes, your lordship.
Yes.
Uh,
All right. What else?
Yes, your lordship, and your lordship kindly come to the complaint, your lordship, that is under 156 clause 3, your lordship. From that itself, your lordship, that is the certified copy, so it is not in,
Yes, it's here.
it's not paginated, your lordship. 156 clause 3. The petitioner against the present petitioners by the opposite party number 2, it was alleged, your lordship, kindly, your lordship is there?
Yes, it is here.
Yes, your lordship. At the bottom part, it is stated as place, date and time of offense. That is on 30th September 2021 at 11 AM. And offences under section 389 and 34 of the Indian Penal Code, your lordship. And kindly consider that the FIR was lodged, your lordship, on 7th, your lordship. The FIR was lodged on 7th of October 2021. There is a delay of 7 days also, your lordship. So that has not been stated what is the reason behind such delay in filing of the complaint, your lordship.
So 156 clause, the order has to be passed after the FIR is closed.
Yes.
Yes, your lordship, and
Let her make her statements. You will get your chance.
and that was also filed on 5th of
You're for the mobile shop owner. Mobile shop owner. Yes.
your lordship, and lordship, and it was also filed on 5th of October 2021, your lordship. Kindly come to the bottom part of the last page of my petition, that is the affidavit portion, your lordship.
Yes.
It is, but your lordship, my question is where the point of section 389 arises, your lordship. I am asking this question to myself as being the sole owner of the property. The petitioner number 2 sold it to the petitioner number 1. So she is presently the owner of the property.
Yes.
And he, the opposite party number 2 has only encroached that property, your lordship. And just to evade any proceedings, civil proceedings, he has filed this 156 clause 3, clause 3, your lordship. And I would like to bring to your lordship's attention to 2 judgments, your lordship. One is the Priyanka Srivastava, and one is your lordship. I would like to.
This was my research. What have you done?
Along with that, your lordship, and at the time of first hearing of the matter, your lordship, the stay was granted, stating the Priyanka Srivastava, citing that only, your lordship. The stay was granted on earlier occasion by Justice Shen Gupta, your lordship. So, your lordship, in Priyanka Srivastava judgment, I would like to bring your lordship's kind attention that in. Pardon.
Yes.
Lordship. So they have not exhausted 154 clause 1 and 154 clause 3, your lordship. That has not been reflected in the complaint itself, your lordship.
Which portion of Priyanka Srivastava read it? Take your time. There's no hurry.
And your lordship, at the time of taking cognizance also.
Para 29.
Yes, lordship.
Read para 29.
Yes, lordship. To the process of law, your lordship, and in this matter, your lordship, they have not exhausted the provision laid down under section 154 clause 1 and 154 clause 3, your lordship. So That from para 26, it would be clear from the para 6 of Priyanka Srivastava judgment, your lordship, that they have not exhausted that also, and that has not been reflected in their complaint itself, your lordship.
Paragraph 6. Paragraph 6 of the complaint.
Yes. All right, anything else?
And moreover, your lordship, that section, they have inserted section 389 in this matter, your lordship, but that does not lie, as the present petitioner is the owner, present petitioner number 1. She is the owner, sole owner of the property of the plot of land in dispute, your lordship, and the opposite party number 2 has encroached into that plot of land, and just to evade any civil proceedings, as the transfer was done in 2020, your lordship, he subsequently has filed this complaint, your lordship.
All right. Yes.
Lordship, under 482, your lordship is well aware that in factual aspect, washing cannot be done. If there is any technical difficulty, then washing can be done under section 482.
So in para 6, which you were reading in the complaint, that you had gone to the police station, what is the evidence that you had gone to the police station, you filed a complaint? Where's the complaint?
That complaint.
Mere awareness is not going to help you. Where is the complaint?
Then lordship, can you take it up tomorrow?
Where's the complaint? Did he file any complaint?
My lord, I'll just come regarding that.
And lordship, regarding the delay, lordship, this is the 156 plus 3, your lordship is well aware that.
Don't worry on the delay part. You just come on the technical aspect of it. Yes.
My lord, for the state, my lord, two things are there. First of all, regarding the 154 clause, which my
yes,
petitioner has stated that it has to be reported as compliance has to be there under section 154(3), my lord.
Yes.
But the 154(3) compliance, the word may is used.
Yes.
The applicant may or may not.
Yes.
So it is his discretion what to do. Now,
No, we are not blaming the state.
My lord, now second is that FIR.
I have only one question to ask.
Where is the FIR which was placed before the police station?
Yes.
That FIR is not in the CD also. They have come directly 160 petition is there, which was treated, which was sent by the SDM, CDM, and
yes,
it was treated as an FIR.
Yes.
Now, thing is that in this case, my lord, whether section 389 will come, because I am for the prosecution, my thing is that yes, 389 will come.
Yes.
And it is very clear because this OP number 2, he was a tenant for the last 16-17 years. And this petitioner number 2 and 3, they have gifted the property to the petitioner number 1, who was their domestic help.
Yes.
Who was their domestic help.
Yes.
And he sold that plot, and after that, they went to the shop, as per the case, my lord.
Yes.
They went to the shop and they asked for vacating the shop. Now, there was a hot altercation and there was a threat on the part of this petitioners, and ultimately a case under section 389 for extortion. Malad knows very well the provisions of section 389. So this is the case. Charge sheet police has investigated the case. 161 of the neighbor shops is also there, who is the adjacent shop owner. His 164 is 161 is also there. Sufficient materials are there, and there is correlation with the FIR also, and charge sheet has been.
Take down. The petitioner in the present petition under section 482 CRPC is assailing the proceedings of Mathili police station case number 173/2021 dated 7/10/2021 under section 389/34 of Indian Penal Code, corresponding to GR case number 5456 of 2021, pending before the learned Chief Judicial Magistrate, Jalpaiguri, and charge sheet number 164/2021 dated 30th/11/2021. Full stop. It is the case of the petitioners that the petitioner number 1, who's a tribal girl, was working as a housemaid at the house of petition number 1, petition number 2 and 3. The full stop. The petition number 2 and 3 sold a small portion of their land to petition number 1 for a meager sum of rupees 5,000 on 13/2/2020 wide a registered sale. Full stop. It is their case that the opposite party number 2 was an encroacher of the said land and he was running his mobile shop from the said plot. Full stop. From the said land. Full stop. However, he refused to vacate the said land and instead he set the criminal law into motion by directly. He set the criminal law into motion by directly filing a complaint under section 156(3) before the learned Chief Judicial Magistrate on 7/10/2021, right? 7/10/2021, without complying with the mandatory provisions as laid down by the Honorable Supreme Court in Priyanka Srivastava versus State of UP, reported as 2015-6 SCC 287. The Honorable Supreme Court in Priyanka Srivastava Supra categorically held as follows. ये para 30-31 judgment का आप लेंगे, ठीक है? On perusal of the record, it shows that the Chief Judicial Magistrate failed to ascertain the truth of the complaint and also the veracity of the allegations made by the opposite party number 2 in his complaint under section 156(3) CRPC. Full stop. The petition number 2 and 3 were owners of the said land in question, and they had sold a part of the land to petition number 1, who was a tribal girl working as a housemaid. Full stop. The opposite party was an encroacher of the said land, claiming himself to be the owner, approached the Chief Judicial Magistrate under 156(3) of the CRPC. Full stop. It is pertinent to mention that the opposite party number 2 is not in possession of any documents to substantiate that he is the owner of the said land in question. Full stop. His submission. The learned Chief Judicial Magistrate failed to verify the truth of the complaint.
Lordship, the document is in the city, Lordship.
What document?
Electricity bill, the trade license.
That's all right. I'm talking about ownership of the land.
Ownership. Yes. He's in possession of the property.
He's just in possession of the land. The learned Chief Judicial failed to verify the truth of the complaint and also failed to insist upon filing of an affidavit as directed by the Honorable Supreme Court in Priyanka Srivastava Supra. Full stop. On perusal of the record जो आपने लिखा है ना ऊपर में, it is the submission of the learned counsel or the petitioner कर देना, जहाँ से sentence शुरू होता है. On perusal है ना, हाँ, it is the submission of the learned counsel for the petitioner that the, हाँ, it is the वो perusal हटा दो. It is the submission of the learned counsel for the petitioner that the Chief Judicial Magistrate. ठीक है? The Honorable Supreme Court recently had an occasion to examine the effect of non-compliance of Priyanka Srivastava Supra in Babu Venkatesh versus State of Karnataka 2022 5 SCC 639. The relevant portion of the said judgment of the Apex Code reads as follows. It's in para 27, 28, 29. Learned counsel for the respondent submits that the respondent had approached the police authorities as mentioned in para 6 of the 156(3) complaint, though there is no evidence to support the same. Full stop. Learned counsel for the state submits that they had not received any complaint from the private respondent, and the investigation was conducted based on the directions passed by the learned magistrate under section 156(3) of CRPC. It is further submitted by the respondent state that they have filed the charge sheet and the allegations as mentioned under section 389 is well made out. This court has already observed that in the matter of Priyanka Srivastava as well as Babu Venkatesh, as quoted above, it is a settled position of law which has been laid down by the Honorable Supreme Court. In view of the same, this court is of the considered view that the respondent has not followed the directions of the Honorable Supreme Court, and that continuation of the present case is an abuse of process of law. Full stop. Hence, the present petition is allowed, and this court is hereby quashing the proceedings of Maithili Police Station case number 173 of 2021 dated 7/10/2021 under section 389. GR case number 5456 of 2021 pending before the Chief Judicial Magistrate, Jalpaiguri, and the charge sheet dated 164 of 2021, dated 30th/11/2021. A copy of the State Jalpaiguri for further necessary action. Full stop.
I'm grateful to your lordship for giving a patient hearing to me.
Anything you want to add, Mr.
जजमेंट में आपको दे रहा हूँ है यहाँ। ये दोनों
Any addition?
इसका पैराग्राफ कोड का।
Yes, Lord.
Yes, Mr. Paul.
Let item number 20, I am not pressing it, my lord. I have instruction to not press it, my lord.
Not pressed. The present petition is dismissed as not pressed.
Grateful, lordship.
You got it settled or what?
My lord. No, my lord.
Then
There was something else involved, but the client doesn't want to proceed with the matter.
it's a case where he's supported by so many judgments.
It's supported, my lord.
It's a quashing case.
And I tried to convince. Although I have brought all the judgments.
Yeah, all the judgments are already, I've seen
Yes,
that.
yes.
It's, you know, 2 judgments of this court,
Yes,
then Andhra Pradesh,
May I
then.
proceed?
No, forget it.
Grateful, lordship.
Lordship, I'm praying for next circuit, Lordship.
Next circuit, why? You think this circuit won't give you anything?
No, Lordship, I have instructed by the advocate on record.
Learned counsel for the learned proxy counsel. What's your name?
Riya Agarwal,
Riya Agarwal states that the main arguing counsel.
Lordship.
Who?
Pratyusha Datta Chaudhary.
Sorry?
Pratyusha Datta Chaudhary.
Pushuta Datta. Pratyusha Datta
Datta
Chaudhary is in some personal difficulty. She seeks an adjournment and prays for this matter to be listed before the next circuit bench. Full stop. Let the same be done. This matter before the next circuit bench.
Branded online, my lord. With a deceptive name, my lord. Your lordship will not go by that name now.
No, I am.
My lord, I'll just keep the mic on mute, my lord.
Yes.
When my time will come, I'll react you.
Here in the second paragraph, the opposite party has
Just a minute. Which order? 13th of?
13th of June 2023, passed by this honorable court.
Yes, yes.
At the time of admission, it was submitted that the opposite party number 2 is a supplier of Nerolac paints.
Nerolac paints.
They were supposed to supply good quality of Nerolac paints, but the paint that was supplied was of different kind and inferior quality.
Yes.
At this point, they have taken, it was taken in this revisional application. They have also annexed certain letters, which are neither supplied, neither issued to the opposite party, nor there is any endorsement apart from this simple signature initial.
Why should we go in there?
Yes, but they are trying to say that the inferior goods was supplied, hence that payment was the remaining payment was not made. They had.
Why should we, Mr.
If I go by the facts, they had the intention to deceive the opposite party from the inception by not paying the entire amount. They have made part payment. They have made 8 lakhs and odd.
Yes.
The remaining 5 lakhs.
Why would he also make that payment if he had the intention?
Yes, that is the point. If the quality of the good is inferior, if they are not satisfied with it, then why did they make the payment? Did they raise any complaint before the appropriate authority or institute a case proceeding against the opposite party? No.
What else?
Yes. Secondly, my lord, they have.
But I am taking short leave, my lord. I have to go for the work, my lord. Banerjee is leading,
They have raised question with regard to the amendment also, my lord. And if you should kindly seize the judgment relied by the opposite party at the time of hearing, wherein it has been stated, my lord.
That S. Kumar one?
Yes, my lord.
That's been wrongly relied on.
I have not relied on the judgment. The magistrate has. And I am the petitioner.
By the opposite party in the court.
That's before the taking of the cognizance.
But
In this matter, the cognizance has been-
when cognizance has to be taken, my lord, after the examination of the complaint, my lord, the examination has been done on the date thereafter, my lord. If you also kindly seize the order dated 18th October 2022. If you also kindly seize this order, the order allowing the application for amendment was passed on 23rd August 2022.
Yes.
Wherein observation was made that in the instant case, the complainant has not been examined under section 22 of the CRPC and no summon has been issued against the accused persons, my lord. Yes. If you also kindly turns the next page, my lord, the order dated 18th October 2022. On this date, the complainant was examined under section 200, my lord. Then summons were issued, my lord. This is the date when the cognizance was taken, my lord. So it was after the amendment.
Yes.
And if you also seize the order, the judgment of the SR Kumar, the Supreme Court has dealt with it. When cognizance.
Where are you reading? Which?
The certified copy.
No, wait a minute.
After this third page of the certified copy, I guess.
Third page of the certified.
After order 23rd August 2022.
See the first order of 2/1/2021.
Yes, my lord.
Peruse.
Yes, on the second paragraph. But the complaint was not examined on that date.
Cognizance taken.
But as per the
cognizance taken. As per the order.
Written.
As per the order.
It has been written erroneously, my lord.
Then why didn't you challenge?
As per this judgment of Eskuba, my lord, the cognizance will be taken only after examination of the complainant, my lord.
No, but that's right. But the court here has, this is the reason why they are challenging it. Mr. Paul, you're arguing against yourself.
My lord, on that, merely a word.
No, sir. These are judicial. How can you say, Mr. Paul, you are a
cognizance is to be taken only after examination, my lord.
So that's a mistake which has been done. That's exactly what I'm trying to point out. It's a mistake the court has done.
Yes, after amendment,
they couldn't have done it.
But after amendment, the examination was done in the present case, my lord. If you also kindly sees the order, my lord.
No.
After the order date,
I don't need to go further. I need to stop here. They have taken cognizance before. They couldn't have done that. It's an abuse of process of law.
On that day, perhaps the complaint was not examined. It was examined
That's the
on a
reason.
later date.
That's why I'm saying that he couldn't have done that. Because the complainant was not examined. So he couldn't have taken cognizance. That has been wrongly done.
Yes,
that is the reason S. Kumar doesn't support you.
Yes, my lord. And one more thing, my lord, the complainant is the company is not before your lordship, and one more director is not before your lordship.
Did you see the recent judgment? I think just yesterday, or even if the accused is not before the court, he will still be eligible to get the benefit given to one person. It is just yesterday, day before, Mr.
Usually,
Banerjee.
They are seeking.
I will look at the
of the proceeding for the petitioners, my lord.
You shouldn't be concerned about the others. It's quite the procedure.
They have prayed for quashing of the entire proceeding, my lord.
Yes.
Against all, my lord. That's why I'm submitting.
Yes. You're the person. The petitioner in the present petition under section 482.
May I just take 1 minute of your lordship?
Yes, Mr.
I'm sorry, my lord. May I just take 1 minute of your lordship? My lord, there is one point of law which my learned friend argued. I need to address that. This is for the ends of justice so far as all our lawyers are concerned. My lord, kindly permit me to agitate this. It will take 1 minute. My lord's pleasure would be to take up 191A. Don't look at a Supreme Court judgment right now, my lord. Your lordship would kindly take up 191A of the CRPC. I'll show your lordship something. Permit me, my lord. Permit me. Because possibly 190 CRPC, 191A.
Yeah. Yes.
Your lordship can hear me? 191A.
Yes.
May I just place the subject to the provisions of this chapter, any magistrate of first class and any magistrate of the second class specially empowered in this behalf. Now sees A, upon receiving a complaint of facts which constitutes such offense. It stops here, right? Upon receiving a complaint of facts. Now my lord's pleasure would be to kindly go to 200.
Yes.
Kindly goes to 200. There's the reason I'm saying so, my lord. I know we are very well abreast with all these provisions, but I will just show one line to your lordship. A magistrate taking cognizance of an offense shall examine on oath. So the precondition of a section 200 is section 191A. It cannot be the other way around. And especially when you have a provision like 192, which is being put in service, my lord, over here by the learned magistrate, which is absolutely justifiable. Your lordship's pleasure would be to kindly see 192. Kindly sees 192. (192) is being put in service over here. Any chief judicial magistrate may, after taking cognizance, make over the case for inquiry or trial to any competent magistrate. Over here, the magistrate is actually transferring the case to another file, which is justifiable. Now, the principle is, my lord, first you take cognizance, then if you think that it is of a particular district and a particular magistrate is looking after that district, then it should be transferred to that file. It is for that particular magistrate to take it under section 200, and then if it wishes to go to 202, it will go. Or else the two options which are left is 203 or 204. So the question of doing an essay first and then taking cognizance, possibly, my lord, is not what is conceptualized in the act. First the cognizance, then the 200, then the 202. If no case is made of 203, if not, then 204. That's what the scheme of things is, my lord. It was my duty to show it to your lordship so far as the code is concerned, and so far as this order is concerned. Your lordship would see what your lordship indicated the cognizance was taken is the absolute case of mine, but it is also the case of 192 being pressed into service. So what he tried to argue that cognizance was taken subsequently cannot be the case, because 190 precedes 192. You have to take cognizance first. So 190 took place, cognizance taken, transferred to another court. That court takes 200 and moves forward. His argument is not tenable in law. In law.
Right.
That is all that I would have to say about
Jalpaiguri is challenging the impugned proceedings in connection with CR case number 02-2021 under section 406, 420, 34 of the Indian Penal Code, pending before the Court of Judicial Magistrate Second Court at Siliguri. The facts leading to the present petition are as follows. Roman 1 karna. The petitioner herein are the directors of MS Money Square Limited, a company incorporated under the relevant provisions of the Companies Act 1956, full stop. The present proceedings emanate from the complaint filed by the opposite party under section 200 CRPC before the learned additional chief judicial magistrate, Siliguri, against MS Money Square Limited, full stop. It is the case of the opposite party that MS Money Square Limited placed orders on the opposite party for supply of painting materials, full stop. The opposite party supplied materials worth rupees 14,694,000 during the period February 2018 to August 2019, full stop. Out of the total outstanding amount of rupees 14,694,000, MS Money Square made a payment of rupees 8,30,484 towards the part consideration of the painting material, leaving the balance of rupees 5,70,210, full stop. It is the case of the opposite party that despite repeated reminders and service of legal notice, MS Money Square Limited failed to make the balance payment of rupees 5,70,210, and hence they committed the offenses under section 406, 420 and 34 of the Indian Penal Code. Roman 2. The learned additional chief judicial magistrate, Siliguri, wide, order dated 2/1/2021, took cognizance of the offences as mentioned in the said complaint and directed and gave direction for registering of a CR case. And further, the case was transferred to Judicial Magistrate Second Court at Siliguri for trial and disposal. Roman 3. Subsequently, the opposite party moved an application for amendment of the complaint, praying for incorporating the names of the directors of MS Money Square Limited as accused persons, full stop. The learned judicial magistrate second class, Siliguri, Darjeeling, wide order dated 23/8/2022, allowed the said amendment application, full stop. The learned trial court comma, later by order dated 17/2/2023 was pleased to issue process to the accused number 2 to 7 mentioned therein in the said amended complaint, full stop. Hence, the said complaint is pending adjudication before the learned trial court for the appearance of the accused persons, full stop. Learned counsel for the petitioner, Mr. Sabyasachi Banerjee, submits that the proceedings pending before the learned trial court is an abuse of process of law, and the same is initiated by the opposite party to harass the petitioner with ulterior motive and damage their reputation and further extort money from the petitioners, full stop. Learned counsel further submits that the quality of the paint supplied by the opposite party was of an inferior quality, and hence MS Money Square Limited had already raised a dispute qua the same with the opposite party and Nerolac Paints, full stop. It is the submission of the learned counsel for the petitioner that the dispute between the parties is purely of civil nature and no criminality is involved in it, full stop. Learned counsel for the petitioner further pointed out that the petitioners were not named in the original complaint and their names were added subsequently by way of an amendment application, full stop. Since original complaint, since there is no provision in the, it is further argued by the learned counsel that there is no provision under the criminal procedure code for carrying out an amendment of the complaint after the court has already taken cognizance of the same, and that the learned trial court ought not to have allowed the said amendment of the complaint, full stop. Learned counsel for the petitioner has relied upon Murari Lal Gupta versus Gopi Singh, reported as 2005-13 SCC 699, and Anil Mahajan versus Bohr Industries Limited and another's reported as 2005-10 SCC 228 to contend that even if the averments made in the complaint are taken to be correct, no prima facie case is made out against the petitioner under section 420 and 406 of the Indian Penal Code, full stop. The learned counsel for the petitioner further relies upon Ravindranath Bajpayee versus Mangalore Special Economic Zone Limited, reported as 2021 SCC online SC 806, to assert that summoning of an accused in a criminal case is a serious matter, and that the criminal law cannot be set into motion as a matter of course, full stop. The learned counsel further relied upon Sunil Bharti Mittal and another versus State of West Bengal, and another reported as 2023 SCC online Cal 812 and SK Alag versus State of Uttar Pradesh and others reported as 2008-5 SCC 662 to substantiate that a director of a company or an employee cannot be held to be vicariously liable for any offense committed by the company itself. Full stop. Learned counsel for the opposite party vehemently opposes the submission of the learned counsel for the petitioner. Learned counsel further submits that the petitioner cheated the respondent with the intention to cause wrongful loss to them, and hence the learned trial court has rightly taken cognizance against the accused persons under section 406, 420, 34 of the Indian Penal Code. Learned counsel for the opposite party further submits that in view of the law laid down by the Honorable Supreme Court in S.R. Sukumar versus Sunad Raghuram reported as 2015 9 SCC 2009. The learned trial court has rightly allowed the amendment to the complaint. Full stop. This court has heard the arguments advanced by both the parties and has examined the materials placed on record by the parties. Full stop. The following facts are admitted by both the parties. 1. Roman 1 Karna. MS Money Square Limited placed purchase orders with the opposite party for the supply of painting material. Roman 2. Based on these purchase orders, the opposite party supplied the painting materials to MS Money Square Limited. Roman 3. The Money Square Limited paid rupees 8,30,484 towards part consideration of the painting materials. Full stop. Next, there is a dispute between the parties regarding the balance payment. Full stop. It is the case of MS Money Square Limited that painting materials supplied by the opposite party was of an inferior quality, and hence they have already raised a dispute qua the same with the opposite party. And
No, not raised, but it is the claim, madam.
okay, painting materials supplied was inferior quality. Full stop. The opposite party disputes the said position. Full stop. Hence, from the facts as emerged from the present case, it is clear that the dispute between the parties are purely of civil nature. Full stop. It is worthwhile to reiterate the observation of the Honorable Supreme Court in Indian Oil Corporation versus NEPC India Limited 2006 SCC 736. इसका एक पैराग्राफ मैं दूंगा, ठीक है. In the present case, इसको लिखवाई दो आप here. While on this issue, उसको paragraph quote कर दो. While on this issue, it is necessary to take notice of a growing tendency in business circles to convert purely civil dispute into criminal cases. Full stop. This is obviously on account of a prevalent impression that civil law remedies are time consuming and do not adequately protect the interest of lenders/creditors. Full stop. Such a tendency is seen in several family disputes also, leading to irreversible breakdown of marriages/families. Full stop. There is also an impression that if a person could somehow be entangled in a criminal prosecution, there is a likelihood of imminent settlement. Full stop. Any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged. Full stop. Inverted comma में ले लेना पूरा sentence. While on this issue करके, ठीक है? जहाँ से है ना while on this issue. In the present case, next, in the present case, the learned trial court has taken cognizance against the petitioner under section 406, 420, 34. Full stop. The Honorable Supreme Court recently in Vijay Kumar Ghai and another versus State of West Bengal reported as to 2022 7 SCC 124 examined the provision of section 405 and 420 IPC in detail and held that unless there is an intention on behalf of the accused persons to cheat the complainant from inception is evident, comma, no criminal offense of cheating is made out. The relevant portion of the said judgment is reiterated as follows. Iska paralena 27 to 28 and 31 to 35. इसमें लिखो 27 to 28, then 31 to 35. Yeah. The perusal of the complaint discloses no offense either under section 405 or 420 IPC. Mere breach of contract in itself is not a criminal offense. Full stop. For breach of contract, one have civil remedies and can seek damages. Full stop. One cannot set the criminal law into action for a purely breach of contract dispute. Full stop. It is to be noted that in the present case, the business transaction between MS Money Square Limited and the opposite party number 2.
Opposite party, sole opposite.
Opposite party. As a Galena, it is to be noted that in the present case, there was a business transaction. There was a purely business transaction between MS Square Limited and the opposite party number 2. Full stop. The purchase orders were placed on the opposite party by MS Money Square Limited. Part payment was made by MS Money Square Limited. Full stop. There is no allegation made by the opposite party against any of the petitioners in the complaint. Full stop. There is no specific averment in the complaint demonstrating the role of the petitioners in commission of the offenses. Full stop. Hence, as held by the Honorable Apex Court in SK Alag bracket Supra, no vicarious liability can be fastened on the directors or employees of the the employees for the offenses alleged to have been committed by the company. Full stop. As rightly pointed out by the learned counsel for the petitioner, criminal law cannot be set into motion as a matter of course. Full stop. Summoning the accused in a criminal case is a serious matter. Full stop. While issuing summons, the learned trial court has to record its satisfaction about a prima facie case against the alleged accused persons. Full stop. The said power must be exercised judiciously. Full stop. However, in the present matter, comma, the learned trial court, comma, failed to record any such reason and issued summons in a mechanical manner without even applying his mind. It is also to be noted that the petitioners were not even named in the original complaint. Full stop. The learned trial court allowed the amendment application and added the name of the petitioner as accused persons by erroneously interpreting the judgment of S.R. Sukumar versus Sunand Raghuraman reported as 2015-9 SCC 609. Full stop. Having gone through the complaint, it cannot be said that the averments in the complaint against the accused persons constitute an offense under section 406, 420, 34 of the IPC. Full stop. In the absence of the basic ingredients of the aforesaid sections, no criminal proceedings can be set into motion and can continue to proceed as an abuse of process of law. Full stop. Hence, this court is inclined to quash the impugned proceedings in connection with CR case number 02 of 2021 under section 406, 420, 34 of the Indian Penal Code pending before the Court of Judicial Magistrate, Second Court at Siliguri. Full stop. Anything else, Mr. Banerjee?
Nothing, my lord. It's just so that we are Money Square Limited. That MS is not there.
Oh,
sorry, my lord. This is just a clarification that I thought that
yes,
MS is not there. I checked also. Normally it's MS only. What your lordship is holding is the correct thing, but unfortunately, it is not here.
Accused number 7 is not there.
The company and the
Accused number 7, my lord, was never a part of the company. He has just added that person from somewhere we don't even know. And I believe, my lord, your lordship is quashing the whole thing. Nothing survives after this.
That's what they're saying.
He's the director, man.
My lord, we can't hear you.
Was he a director?
My lord, he was never with the company. Otherwise, we would have represented him. We don't even know him. But that's my instructions. And my lord, I believe my lord, I believe your lordship is quashing the whole proceeding so that I don't have to come back again for the company.
All right.
Quashing the whole proceeding. My lord, I couldn't hear the last part. My lord, your lordship is quashing, right? Quashing the whole proceeding.
I'm only quashing these proceedings. That's it. Whoever is the beneficiary of this proceeding will be
deeply obliged. Deeply obliged. Deeply obliged, my lord. That's all. That's all.
Just take down. The present proceedings have been quashed for the parties.
My lord, I am beseeching your lordship will not observe that. Because then I would have to bring the company again. It will be a travesty, my lord. So it will be a complete travesty, my lord. This will be a huge visual waste of time. I would beseech your lordship that this kind of complaint should not continue, my lord.
You cut the last line. No, I don't need to give clarification.
Deeply obliged, my lord.
Here is here.
But your lordship is not audible.
Your accordance, whatever you do it.
But your lordship is not audible.
It won't be interpreted at all.
Yes, my lord.
It is only for the petitioner. I'm not giving a clarification to that extent at all. I'm not giving a clarification. They will be beneficiary, and the Supreme Court has observed very clearly today. Read the judgment of days back. It is very, very clear that even if you are not a party and there's any benefit which is flowing out of it, everybody is entitled to get that benefit. Day before yesterday, the Supreme Court has observed. It is Justice Oak and this was called. Read the judgment.
Deeply obliged, my lord. Great for all the indulgences, my lord.
Yes.
My lord, the video is frozen. I don't know whether I'm audible, inaudible.
Both are disclosed. All pending applications are also disclosed.
My lord, grateful, my lord. Grateful.
ये जजमेंट सर ना अगर चाहिए होगा ये जजमेंट है ना अगर तुम्हें कुछ कोट करना होगा फिर वापस करना मुझे वो
My lord, grateful, my lord. I don't know whether I'm audible or not. Next matter.
फाइल है ना फाइल याद है ना Next.
Sham for the petition. The whole matter is relating to the violation of section 82
There is
proceedings.
no violation. You submit yourself to the court.
Yes, Lordship.
There's absolutely no violation. You withdraw this or I dismiss it. Where is Mithun Mia?
Where is?
Where is Mithun Mia? Has he submitted it before the court? Has
No,
he
Lordship.
surrendered?
No, Lordship.
So why proceedings can't be initiated against him?
No, sir, I'm telling Lordship.
Read the orders.
Yes.
Where's the question of any illegality or perversity in the order?
Illegality is that there is no, the petitioner has not been.
Mr. Saha,
Yes.
if you want, I'll dismiss it. If you want to withdraw, you withdraw it. My observations will harm you. That much I can tell you. And you read the orders. I'll show you the orders. Read the orders. Come to page 30, annexure P6. Third line from the top. The record shows that the respective accused persons were absconding for long and that proclamation proceedings were completed against them. All right.
Page 28.
Then you read
Page 28.
page 30.
30.
This is the order of 15th of April. Third line from the top. Then you turn the page 31. Third paragraph, second line.
Sorry, Lordship, 30, that is Lordship CRR number 233.
This is CRR number 234.
233, can you see, Lordship? This is the
You
first.
see any one, it's the same thing.
Yes, sir.
You have to understand there were three people who were there. Mithun Mia, Hakim Mia, and what is the other name? Only one person has submitted himself before the court who got bail and the proceedings under 83 has been dropped against him. The rest of the two have not surrendered. Proceedings are there and it's rightly being conducted. There is what is your,
Yes, Lordship, I got the order.
there is no illegality, Mr. Saha.
Lordship, I'm showing Lordship. Lordship has reading out from the page number 30. It appears from the record that the instant accused person.
Your argument and your ground that proceedings under 83 have not been rightly carried out is not correct.
I get from the order from the Lordship from the provision of law.
See, there are three people: Hakim Mia, Karim Mia.
Yes.
Right.
Yes.
They are the ones who have, and one more, Mithun Mia.
Yes.
So one person, Mithun Mia and Hakim Mia, have not surrendered.
No.
All right.
Yes.
And that is the reason why 83 proceedings have been taken out against them.
Yes, Lordship.
The warrant of attachment regarding their property has been there. The other third person was also part of it, but against them, the warrant of attachment has been cancelled. Once he surrendered.
Yes, definitely, Lordship.
Right. So now it is only pending against two people.
My submission is that, Lordship, the impugned order in CRR 233 is this. The proclaimed offender is a judicial order that needs to be done in accordance with law. That is particularly section 82 subclause 4. So the petitioner has not been categorically declared, pronounced first as the proclaimed offender and then declared.
This go submit yourself. Go and surrender. Go and surrender. First, go and surrender. You are absconding.
Listen, I have a right of paper.
Why don't you go and surrender? You have a right to abscond.
No, I have a right.
You have a right to abscond.
I have a right to paper and executive bill.
You go surrender yourself. All these proceedings will get over. Go and surrender yourself.
Then I have to withdraw this application.
Sorry?
Then I have to withdraw this application.
Yes, withdraw this. Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. All the four matters.
Lordship, item number 28, kindly fix it at 2.
Why,
Kindly fix it
Pratyusha?
at 2. Lordship, I'm preparing matter. Kindly fix it at 2, Your Lordship.
You're preparing it.
Yes, Your Lordship. Or pass over or fix it at 2, Your Lordship.
And nothing much in this matter.
Yes, Your Lordship. Only for the admission of the revision or application.
All right.
Quickly, Your Lordship.
What, you just got the matter or what?
Yes, Your Lordship.
Did you just get the file?
Yeah, matter, I'll just note.
Come before lunch, try to finish it off. There's nothing much. This notice has to be issued.
Yes.
You are Miss Pratyusha, right?
Yes.
Dusra, second. Passover. 28 is Passover. 29.
For the petitioning of this.
Yes.
This is the affidavit of service. I have already handed over, served the copy to the state. Now, my lord, my only grievances would be before your lordship, which have highlighting before your lordship, that if your lordship kindly take the page number 11, the charge sheet was filed on 7th January 2012. Now, lordship, relying the judgment passed by the Honorable Supreme Court, just for the purpose of appreciation, I am mentioning that prior to the submission of charge sheet, I was on bail.
When is the next date? 21st of September?
Lordship.
Go before the court, seek a bail.
Lordship, no.
I'll suspend it for 2 days till 21st. Your warrant of arrest.
Lordship.
Take down. The petitioner is aggrieved by the impugned order dated 6/9/2014 and all other subsequent orders passed in GR case number 1833 of 2008 pending before the court of Learned Chief Judicial Magistrate Jalpaiguri. Full stop. Learned counsel for the petitioner submits that the petitioner was named and accused in FIR number 299 of 2008 under section 302/201 IPC dated 27/2/2008, Bhakti Nagar PS, corresponding to GR case number 1833 of 2008. Full stop. After being released on bail, his then lawyer, the lawyer of the petitioner, after being released on bail, the lawyer of the petitioner told him that there is no need to appear before the court till the filing of the charge sheet. Full stop. His counsel told him that the court will issue notice to him after filing of the charge sheet. Full stop. Since no notice was received by him, he was under the bona fide impression that no charge sheet has been filed. Full stop. On 1/9/2023, some police personnel attached to the Kotwali police station visited his house and informed him that a warrant of arrest, informed his family members that a warrant of arrest has been issued against the petitioner. Full stop. Based on the said information, he consulted his lawyer and applied for certified copies of the order and came to know that the charge sheet has already been filed on 7/1/2022, 7/1/2012, and warrant of arrest was issued against him, while order dated 6/9/2014, and again on 15/6/2023. Full stop. The petitioner is directed to surrender before the Learned Trial Court on 21/9/2023. Full stop. The petitioner is at liberty to approach the trial court for bail. And in such an event, the Learned Trial Court will consider his bail application in accordance with law. Full stop. The warrant of arrest issued against the petitioner shall remain stayed till 21st of September 2023. Full stop. With these directions, the present petition is disposed of.
One indulgence. Today is the 28th, maybe fixed on 22nd, because I have to inform my client.
21st, when the date is there in the
No,
court.
Lordship. So for the last date is concerned, that is in the certified copy, that is 14/9.
No, the after that is 21st of 9.
Lordship, if I have to
21st.
Lordship.
Next.
Copy them. Xerox করে দিচ্ছি কেন এটা কপি তো লাগবে আবার ঠিক আছে না আমি এটা ফিনান্স ট্রান্সমিট হয়ে গেছে দিয়ে দিচ্ছি Malad, here
yes,
proceeding under section 133 has been issued, initiated, Malad.
So what do you want?
But difficult,
I
difficult
can't,
that
I am not going to cost the proceeding under 133. Why don't you participate there?
133 should be
Yes.
should
Where
be
there is a
where
question of any
public nuisance.
public nuisance.
But here
So
the
this
dispute is
can-
between among two individuals, my lord.
No, but it can cause.
Add to that, on the same issue.
Mr. Paul, I know there is an animosity between both the parties.
Yes.
But it can also lead to a public nuisance. Two fights between the persons is not only confined.
It is not
to their-
reflecting from the complaint.
So they have not concluded yet. These are just proceedings which have started. You can make the same submission over here rather than coming here. The proceedings are still going on. So why have you come here today?
But my lord, from the complaint.
Why do you want an observation from this court?
No, my lord.
That the proceeding,
the
you expect me to quash the proceeding? I will not. quash.
Magistrate taking
So you can go and
taking note of the complaint ought to have looked into the
Mr. Paul,
allegation, my lord.
Mr. Paul, today, whatever it is, a complaint has been filed. He has taken note of the complaint. Investigations are going on. Nothing has happened. You can participate in there. You can raise all the points which are there available for you. Why have you come here?
Because the initiation
Because
under
you are-
section 133 is a.
I don't agree with that submission of yours. A fight between two people can also call public nuisance. It can cause public nuisance. That submission, I'm not impressed with.
Allegations are very specific.
Go there and say that, no, that there's a previous.
Deal with the allegations.
So they'll deal with the allegations.
The allegation is clear that it doesn't.
You want an observation? So you want me to decide it? I'll decide. I have no problem in deciding.
Well, let it place before next circuit.
No, why should I? This is not done. See,
Well,
Paul, I'll decide. Then you argue, I'll decide.
Yes, my lord. If you also kindly sees the complaint, comes to the complaint. Page 23.
I have seen the complaint. Yes, tell me. What do you want to say?
Yes. Well, there should be some allegation where the public at large are affected. There is nothing like that. And prior to that, and this dispute is going on since very long, my lord. They have been constructing a building. The complainant has been constructing a building without any sanction plan. I made a complaint, my lord, before the concerned authority, my lord.
Yes.
There was an inspection held. He failed to produce any document.
See, we are not getting into that. You're right.
Yes.
See, that recourse you always have. If somebody is illegally constructing something, you know what to do.
But the provision is
You
very
go-
clear. There must be, if you also kindly sees the provision, my lord.
I have seen that provision. That's why I'm telling you.
But that's why I'm submitting. My lord, the provision is very clear. Let me serve and come then, my lord. Let me serve and come.
Mr. Paul,
Well,
there is absolutely nothing in.
But this is not a proceeding under section 144, my lord.
It is not. 144 is entirely. This is not 144 at all.
Yes, this is very specific provision.
It is.
But the allegation
Causing public nuisance.
Yes.
That is what it says.
Yes. But there is no allegation as such.
If a fight takes place and people are involved in it, won't it call public nuisance?
My lord, he is what he is alleging that I'm obstructing
today-
his way,
So
his
today,
path.
so
This is the allegation.
you have come, the proceedings have not concluded.
The way
You are saying that 188 is not attracted at all. The
if
DM
the
could not have
path has
issued.
been used for the public at large, then it attracts 133, my lord.
All right.
It was specifically used, as per his allegation, it was used for the by the complainant, my lord. And I am restraining him. Then it is purely dispute between two individuals, my lord. But that is
Take down. The petitioner in the present writ petition under section 482 CRPC is challenging the proceedings being petition case number 50 of 2023 initiated under section 133 and 142 of CRPC pending before the court of special executive magistrate Siliguri metropolitan area Siliguri. Learned counsel for the petitioner submits that the opposite party number 2 is carrying out unauthorized construction at his site. And hence the petitioner had approached various authorities.
even the High Court also.
To stop the unauthorized construction, full stop. It is a submission that due to their personal animosity, the petitioner has lodged an unsubstantiated application under section 133 and 142 CRPC against the petitioner, concealing their previous history of animosity. Full stop. Petition case number 50 of 2023 was registered based on the said unsubstantiated application of the opposite party number 2. The learned special executive magistrate took cognizance of the said application and directed the block land and land reforms officer, Matigara block and inspector in charge, Pradhan Nagar, to submit their respective report involving the issue as alleged by opposite party number 2 in his application. Learned counsel for the petitioner further submits that prior to lodging of the present proceeding at the instance of the opposite party number 2, the inspector in charge Pradhan Nagar PS registered a Pradhan Nagar police station case number 462 of 2023 dated 30th/6/2023 for commission of offence punishable under section 341, 325, 506, 34 of IPC, read with section 3(1) RS 1 bracket R small S small of the SC/ST Prevention of Atrocities Act 1980. The petitioner submits that they are cooperating with the police authorities in the said investigation. It is the contention of the learned counsel for the petitioner that the complaint does not warrant any merit since the same is registered under section 188, which means that any public nuisance should be
133.
133, sorry, just qualify.
Which is the combination of the learned counsel for the petition and the complaint does not having any merit since the same is registered under section 133
of 133 of the CRPC, civil procedure CRPC, which shall only be registered in cases of public nuisance. It is a submission that since the dispute is only between two people, two individuals, there is no question of any public nuisance, and that the complaint is devoid of any merit. This court has heard the counsel for the petitioner and perused the available records. The perusal of the impugned order reveals that the learned magistrate has only directed the block land and land reform officer, Matigara block, and inspector in charge, Pradhan Nagar, to submit their respective report involving the issue as alleged by the opposite party number 2 in his application. Full stop. On receiving a complaint of this nature, it is the duty of the learned magistrate to conduct an investigation to ascertain the veracity of the allegations contained therein. There is no illegality or infirmity in the impugned proceedings. Full stop. this court is not inclined to interfere with the impugned proceedings. The present petition is devoid of any merit. The same is dismissed.
Grateful.
They have not concluded anything, Mr. Paul. I didn't want to give any observation. That's why I was telling you to withdraw it. Why do you want any observation from this court? Now, the district magistrate unnecessarily will proceed with this. That's why I asked you to withdraw it. I'm still open to that. You want to withdraw it, withdraw it.
I'm withdrawing it.
The present writ petition is, the counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Don't take observations. It will harm you.
Grateful.
Next.
Your
Yes.
Lordship, I am for petitioner.
Yes.
Your Lordship, I have filed the application under section 482 of CRPC for quashing of MR case number 173 of 2022.
Why they don't have a right?
Your Lordship, I'm coming to the fact actually.
Yes.
Yeah, actually the fact of the case is that, Your Lordship, on dated 21st July 2022, a complainant, namely Ruma Roy, lodged a complaint in the court.
Ruma Roy is your wife.
Yes, Your Lordship.
So it's not a stranger.
Your,
She has filed a complaint under section 125.
yes, Your Lordship,
So-
for maintenance, and Your
So
Lordship,
the court is seized of the matter. They'll decide whatever has to be done. Why have you asked for the quashing? They don't have a right to file 125.
Your Lordship,
She's your wife.
I have filed the case under section 9 of Hindu Marriage Act, stating that I want to live with her, but she, in written objection, she didn't reply that she want to live with me.
So
And-
more reasons to pay her. You want to live with her? Support
Your
her
Lordship,
also.
she don't want to stay with me. She has married to someone else. She's pregnant of some. She's about to give birth to the child of the another person, and she has already married 2 times, except like leaving me. Then how could I pay the maintenance? It is the violation of section 125, subsection 4 and 5 of CRPC, Your Lordship.
All right. The present petition under section 482 CRPC is challenging the proceedings being MR case number 173 of 2022, dated 21/7/2023 under section 2022 under section 125 of CRPC, pending before the court of learned judicial magistrate, third court, Alipurdwar.
Yes.
Full stop. The marriage between the petitioner and the respondent was solemnized according to the Hindu rites and rituals on 26/4/2021. Full stop. It is the case of the respondent that the petitioner and his family assaulted and tortured her, and she left the matrimonial home on 21/5/2022 and has been staying at her paternal home. The petitioner is a school teacher.
No, Your Lordship, he's sweeper.
A sweeper. The petitioner is a sweeper presently working at Kendriya Vidyalaya.
No, he's sweeper in railway, Your Lordship.
The petitioner is a sweeper in railway. And full stop. It is stated that the petitioner is a sweeper in the railways. Full stop. It is noted that it is a legal right of the wife to get the maintenance from her husband. Full stop. The parties are living separately from 21/5/2022, and that the respondent is unemployed. Full stop. The petitioner is a government employee. Full stop. Hence, this court finds no reason to restrict the respondent from exercising her legal rights under section 125 of the CRPC, seeking for maintenance. Full stop. The petitioner is at liberty to raise his objections before the learned trial court. Full stop. This court finds no reason to interfere with the present proceeding, and hence the present petition is dismissed.
Your Lordship, kindly look at the few documents I would like to submit.
You show all the documents. The case is, they have not decided anything. How can you restrict your wife from filing?
Your Lordship,
125 maintenance.
Your Lordship, actually order has already given 3,000 per month.
So where is the order?
Your Lordship, I have attached that order.
So pay the money.
Your Lordship, but she has married twice.
So what?
Except leaving me.
So what? If she has married twice, this is the matter which is there pending.
Your
Not
Lordship,
today.
she is living in adultery. How could-
Adultery, there's nothing like adultery.
Your Lordship, kindly see this.
Adultery has been shut, you know what has been done by the Supreme Court as far as adultery is concerned.
Your Lordship, in many cases, the order is granted in favor of husband.
Move an application, tell the court there. All this fact was before the court. Was this fact before the court?
Yes.
While
sir.
passing 125, show the order that these facts were before the court.
Dear. वहाँ अलीपुरद्वार में ऑर्डर से हो चुका है वहाँ पे एडवोकेट नहीं वहाँ से ही हो जाएगा
Nothing is there.
Your Lordship,
You have not put anything, not even a word in the order, not even a whisper about it in the order. You make all these submissions before the court. ये रंजन आप इसको वो रखें. Nothing is there, madam. Nothing is there in the order. All that you are making a submission of, nothing is reflected from the orders. Look at the order sheet. You have not placed anything before the court. Adultery, blah, blah, blah. Nothing is there.
Your Lordship, kindly grant permission to us to file the reply of this order in the
You
honorable.
do whatever you have to do before the trial court. Either you withdraw it. You withdraw this petition, go before the trial court, place your facts over there. But this petition is not maintainable.
Your Lordship,
There is no reason for this court to interfere in that.
but lower court has already given the
Move an application.
Move an application to stay. If the stay is not allowed, then.
Move an application. This is just an interim order because you have not placed anything on record. What you are making,
Your
the
Lordship,
submissions which you are making here is not there. You want to withdraw it?
yes, sir.
Learned counsel for the petition seeks to withdraw the present petition. The same is dismissed as withdrawn. Make these submissions before the trial court.
Okay. Why is that?
ठीक है ना?
Sorry.
On instruction, I am paying for next circuit. Lordship, the matter is filed by the advocate of the principal bench. He will come next circuit. Lordship.
Okay. This one I'm looking at.
Who's for the petitioner in this? Somebody was there?
Yes, she might be.
She
For
was-
principal bench.
Was she there in the morning?
No, Lordship.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed before the next available circuit bench. At the request of the respondent.
No,
Let-
Lordship, I'm for the petitioner.
Oh, you're for the petitioner?
Lordship, I'm paying for the petitioner, Lordship.
All right. See,
Proxy counsel, lordship.
proxy counsel so and so appears and states that the main arguing counsel is in some personal difficulty. She requests for an adjournment for the matter to be listed before the next available circuit bench.
Grateful, lordship.
Grateful, lordship.
The last line, Kadana, let this matter be listed before the next available circuit bench. Yeah. Which one is this? 13. Where is he? He was here in the morning. Mr. Saha, we'll pass it over, let him come. Who appears for the, you appear for the government in this matter?
No matter.
Item. Okay, on the civil side, who's there?
Side matter, Mr. Ghosh or even the Mr. Mominur Rahman.
Not then.
Despite second passover, none appears for the petitioner. It is noted that the matter was twice passed over on 15/9/2023. And there was no appearance on behalf of the petitioner. Today also there is no appearance on behalf of the petitioner. It seems the petitioner is not interested in pursuing the present writ petition. The same is dismissed in default.
Fifteen, my lord. My lord, kindly see the last order, my lord.
Yes.
On 12th of July 2023, my lord.
Which one?
July 12th of July, my lord, 2023.
Yes.
My lord, from the report, may I read, my lord?
From the report of the department, it is
yeah.
found that requisite dates for obtaining the certified copy of the award has not been supplied for furnishing report on the point of limitation. Let copy of the certified copy be sent to the learned tribunal for necessary insertion of the dates.
My lord, in compliance to the order, my lord, on 5th of August, the certified copy sent back to the learned court, my lord.
Yes.
Third court, Jalpaiguri.
Yes.
Additional third court. And he sent the report on 7th of August, my lord.
Where is that report?
There, my lord, in record, my lord. Now, after the petition, my lord, it was tagged. After petition, my lord, I see. And learned judge said that due to the inherent mistake, it was not endorsed in the certified copy, my lord. And he said that in the report, my lord, I obtained the certified copy on 5th of December 2022.
When did you obtain it?
5th of December, my lord. 5/12/2022. And it was written in this certified copy also, my lord. I mentioned it, my lord, in my CAN application for limitation, my lord. But though it is not mentioned in the certified copy, so your honorable court said that it was sent back to the court, my lord. I mentioned when I was in CAN application page number, my lord, page number 4, my lord.
We'll have it tomorrow.
My lord, kindly pass an order that I will send the notice to the other side, my lord.
I'll send the, I'll issue notice tomorrow. This. Kal ke lena. Tomorrow.
Tomorrow.
Any other password?
Item number 28.
You need more time to read.
No. Lord will do it. May it please your lordships. Lord, this is an application, my lord, preferred by the husband and the in-laws. My lord, seeking quashment of the proceedings, my lord, under the domestic.
Husband or the father-in-law, mother-in-law?
My lord, all three, my lord.
All three.
All three. My lord, before my lord, I place facts, my lord. Some facts which are not the subject matter, my lord, it's required to be placed before your lordship. That, my lord, after the marriage, my lord, the in-laws as well as the husband, my lord,
Staying separately for the last 3 years.
yes.
Yes.
They are staying separately, but prior to that, my lord, what has transpired and how the situation has occurred, my lord, that requires to be placed. This lady, my lord, she used to take the money of her husband and used to invest in different my lord, investment modules without the knowledge of the husband. And my lord, several lakhs of rupees, my lord, has been duped by herself. My lord, his husband has been duped. Thereafter, my lord, the husband has preferred a police complaint. And my lord, that in that case, my lord, charge sheet has been submitted, and thereafter, my lord, they have parted their ways. They are staying separated, my lord, since 2019. My lord, the husband has preferred a divorce proceedings. That is also pending, my lord. And thereafter, my lord, this application, my lord, has been preferred by the wife against the husband and the in-laws. Now, my lord, when they are staying separately, my lord, since 2019, admittedly by the wife herself, my lord, how could, my lord, the provisions of the domestic violence act could be invoked against the husband and the in-laws? My lord, in her own application, my lord, she has stated, my lord, if the issue is maintenance, my lord, maintenance can be claimed under section 125 CRPC. My lord, there are other laws, my lord, which specifically deals with the issue of maintenance. But my lord, the invocation of this statute, my lord, cannot be independently, my lord, without the fact of, my lord, the domestic violence being perpetrated upon the lady.
You have served the respondent?
No, my lord. This is at the admission stage, my lord. That is moved ex parte, my lord. After your lordship directs, my lord, we will serve.
See, I'm inclined to stay as far as petition number 2 and 3 are concerned. 1, you have to deal with it.
My lord.
Take down. The petitioners in the present petition are challenging the proceedings, being miscellaneous case number 58 of 2022 under section 17, 18, 19, 20 and 22 of the Prohibition of Women from Domestic Violence Act 2005, pending before the Judicial Magistrate, First Class, Fourth Court at Siliguri District, Darjeeling. Next, learned counsel for the petitioner submits that the marriage between him and the opposite party was solemnized on opposite party number 2, right?
True.
Was solemnized on 14th
2012.
14/4.
Yes.
14/4/2012, and a baby girl was born out of the said wedlock on 14/2/2018. Full stop. Due to their matrimonial differences, from 2/9/2019 onwards, the parties are living separately. Full stop. The petitioner filed MAT suit number 572/2021 before the additional district judge, Alipur, full stop. As a counterblast to the same, the opposite party number 2 has filed the miscellaneous case number 58 of 2022 under section 17, 18, 19, 20 and 22 of the Prohibition of Women from Domestic Violence Act 2005, pending before the Court of Judicial Magistrate, First Class, Fourth Court at Siliguri, Darjeeling. Full stop. Learned counsel for the petitioner submits that the petitioner number 2 and 3 are senior citizens Full stop. Petition number 2 is a cancer patient. Full stop. It is the contention of the learned counsel for the petitioner that on the plain reading of the complaint, it is apparent that no prima facie case is made out against the petitioners. The allegations are vague and omnibus kar do isme. It is the contention of the petitioner that the complaint contains vague and omnibus allegations against the petition number 2 and 3. Petition number 2 and 3. It is further contended by the learned counsel for the petitioner that opposite party number 2 has initiated the present proceeding after 3 years of leaving her matrimonial home. Full stop. It is contended that there is no instance of any domestic violence as alleged by the opposite party number 2 during the past 3 years, and that the petition number 2 and 3 were staying separately from opposite party number 2. Full stop. Looking at the complaint and the vague and omnibus allegations against the petition number 2 and 3, this court is inclined to stay the proceedings qua petition number 2 and 3. Full stop. It is further observed that petition number 2 and 3 are aged parents of petition number 1 and were not staying with the opposite party full stop.
Well, one thing may I?
And hence there is no prima facie case made out against them. Full stop. Hence this court deems it appropriate to stay the proceedings against petition number 2 and 3 for a period of 4 weeks. Proceeding in case number kar dena, case number so and so. Case number 58 of 2022 before the Chief Judicial Magistrate, First Class, 4th Court, Siliguri, District Darjeeling, for a period of 4 weeks. Let this matter be available before the next circuit bench.
My lord, may I indicate, my lord, one thing? Since the father of the petitioner number 1 my lord, is a 3rd stage cancer patient, and my lord, he is the only person looking after his parents at this stage, my lord. So if for some time, my lord, if it is stayed, because he requires my lord, radiation, chemotherapy and all those things, my lord, for a limited period, my lord.
Not against.
My lord, liberty may be given, my lord, after service to renew the prayer.
Liberty to mention after service on the
liberty to pray for stay, my lord, for 1.
No. Liberty to the mention the matter.
Grateful.
He's purposely not coming because I told him that I'll dismiss it. Mr. Burman, Mr. Saha has run away.
Probably he also was not solved this matter.
No, he doesn't have a case. He's asking for a Mr. Saha. Yes, I thought you ran away after hearing my comments. Yes, what do you want to do, Mr. Saha? You are there in this matter, Mr. Burman.
Service lordship, the effect, the party is respondent number 1 is the DM. I have service and ability of service I handed over lordship. They have to serve 1 copy in the LR. No, LR office because LR is not the party lordship. State is not the party. The DM is the party. DM is
give the copy to him. You appear now for the DM. Give a copy. We'll have it tomorrow.
Lordship.
Give a copy to him.
Lordship.
We'll have it tomorrow. Keep it tomorrow.
One number to the.
Give a copy to Mr. Burman. Not today. At the request of the learned counsel of the petitioner, let this matter be listed tomorrow.
Lordship, 14 matter has been placed to dismiss.
Yes, yes. Give your appearance, Mr. She never came. That day also I was waiting, but I think she is not interested in pursuing the. That's the problem. Anything else? Mr. Saha, think about it. Think about this matter. There's nothing much.
That matter.
Item 13.
Oh, that matter.
Yes. You want recovery? I'm not going to give you recovery.
I was contemplating that article. My claim is confined under article 299.
Get some authorities on.
Yes.
Phone number.